welcome everybody. I know people are just joining at the moment, so I'll give a few minutes for everybody just to join in, but you're very welcome this afternoon. I appreciate everyone taking the time out because I know how busy a time of year this is as well. So you're all very welcome. So for anybody this is their first time joining us today, my name is Niamh McCarthy. I manage the parental advocacy services for Barnardo's, which are located in Waterford, Wexford and Dublin North City. And we have an information and advice, which is a national service. And we have some free phone numbers that we will put in the chat as well and make available for people. I'm joined today by Stephen Cahill, who is the managing solicitor at Chancery Street, and today we're going to be looking at the topic of interim care orders. As some of you know who have joined us before, there's a whole series of webinars that can be accessed on both the Legal Aid website and our own website, the Parental Advocacy website. So we'll put up all those links at the end as well. But to date, we've covered a number of the care orders, including emergency care order and supervision order. So I welcome people, if any questions come up or they want to revisit that, those recordings are available as well. Today, we're going to focus on the interim care orders, and we have a mechanism to get some questions from people as well. So I know a few people have sent in some questions, which is great. And some of the parents we work with has also put some questions to us to put to Stephen. This is recorded, and please feel free to use the chat if you would like to make a comment or put a question to either myself or Stephen. So you're very welcome, Stephen. Thank you for your time. So as we said, we've kind of covered what a supervision order is, what emergency care order. So we're moving on to an interim care order. And I think we've kind of touched on the interim care order throughout the various webinars. But just for clarification, could you explain to us what is an interim care order?
Sure. So an interim care order application is one that is brought by the Child and Family Agency to the childcare courts that is ultimately seeking for the child to be placed in the care of the Child and Family Agency for a period of 28 days. And that application is brought in circumstances where the social workers and the Child and Family Agency would have certain concerns about the parent's ability to meet the child's needs or to keep the child safe in the longer term, as opposed to the emergency type applications we discussed previously.
Okay, so 28 days seems quite a short time. So what happens after the 28 days?
Sure. So the initial application is, if it's granted by the court, for a period of 28 days. So that's the longest period of time the court can make an interim care order for. However, once that order expires, the Child and Family Agency will almost certainly return to court and look to extend that interim care order for another 28 days. And that process will continue. So they'll return to court every 28 days and look to extend the interim care order unless and until the social workers are happy to return a child to their parents, or the court is satisfied or is no longer satisfied that interim care orders are necessary. So yes, so while the initial application is for 28 days only, the reality is that it usually starts this process that is much more drawn out, albeit in court every 28 days.
And so when a parent is going to the initial hearing or subsequent hearings, like what can they expect? Is it a long hearing? Will there be a lot of evidence, or is it a full day, or what can they expect from that setting?
Sure. So the application, first of all, should be brought on notice to a parent. So there should be a minimum of 2 days notice given to a parent. That then gives an opportunity for the parent to avail of legal representation. They can apply at their nearest law centre for a solicitor. and they can be given urgent legal advices. An interim care order is an incredibly serious application that has such far-reaching consequences that you have you have a full entitlement to fairness of procedures and to have full and effective legal representation. So quite often, the initial interim care order doesn't proceed on its first day in court unless there's kind of very specific circumstances. And that's usually to allow the parent to more fully engage with their lawyers, to prepare a defense, to read all of the reports and whatnot.
Okay.
So it is a very significant application.
Yeah, and if once a parent reads all the reports and they've um, prepared their solicitors, they may have want to gather further reports or can they gather people to give evidence as well, or how does it all work?
Yes, so in the first instance, the burden will be on the Child and Family Agency to set out what their case is and how they believe that meets this threshold for an interim care order to be met. As part of your preparation for that case, you then are entitled to not just question and cross-examine on the CFA case, but you're fully entitled to prepare your own defence. And that may be done just by way of you, the parent, giving evidence, or by calling alternative evidence that you say controverts or perhaps goes against the Child and Family Agency's case.
And is there a time limit on how long the hearing will last for Stephen?
No, so the hearing will last until it is determined by the court. It depends on the complexity of the case, the number of witnesses. There may be a number of expert witnesses called, which may prolong it. So interim care orders can go on for a number of weeks at hearing in the more complex and contentious matters, while others may be dealt with in a much shorter period of time if it's more straightforward or the issues are much more net.
Okay, and will there be a hearing every 28 days, or does the judge need to just hear new evidence, or how would that work for the parent?
So once the initial interim care order application starts, the starting point is that there's no order in place. So that hearing will just continue until the judge concludes it. So if the case commences on a Monday, it may run for the Monday, Tuesday, Wednesday, and then a court can make a decision. And if the court makes the order, then it returns to court 28 days after that.
Yeah. And will the judge, on the second hearing, then, will the judge hear all the same evidence, or will they only hear new evidence to make an additional order?
So that's a very important question, because the making of the initial interim care order is the most important order. When the Child and Family Agency look to extend an interim care order, they don't need to reprove their case. They don't need to show the judge why an order was necessary in the first place. All they have to do is to show that the circumstances that gave rise to the making of the initial order still exist. So there's almost a kind of flipping of the burden almost onto the parent to be able to show that circumstances have changed, or whatever concerns were present have now been addressed sufficiently.
Yeah, because a lot of parents will give feedback that 28 days is such a small window as well in order to make meaningful change. And I suppose that the difference being that family life has totally changed as well, in terms of your children are no longer living in your house. So there's different responsibilities in terms of different appointments, different social work meetings, different access meetings and things. So if parents felt they needed longer time to meet the changes or to engage with the therapeutic sports or to make the changes necessary, can they request for not to come back into court in 28 days?
Yeah, so orders can only be made for 28 days unless both parents or guardians agree to the order being for longer than the 28 days. And you're right, that is usually done where a parent or respondent might accept that whatever steps they're being asked to take will take longer than the 28 days. So sometimes, however, even if you accept that and there's reason to allow the court to make an order for more than 28 days, you may still only actually agree to 28 days because there may be other issues arising that you would want before a judge in 28 days, that you wouldn't be satisfied for that to go on for a number of months, for example.
Yeah, and some of those issues that parents raise are things like maybe goalposts being moved a little bit, in their opinion, around access arrangements, or they're not happy with children's placements, or more or newer tasks being asked of them. And can they bring that kind of feedback back into the court, Stephen?
Yeah, absolutely. So during the court proceedings, I think it's likely that the Child and Family Agency will be asked to really set out quite clearly for the parents what steps it is they're being asked to take. And then further to that, how is that actually going to be measured and reviewed?
Mm.
So that would hopefully kind of stop this perception of the goalpost being moved or changed. Now, sometimes there might be legitimate reasons for
Yeah.
requirements to change, but it can't be done arbitrarily. And these are matters that you can talk to your solicitor about, but will naturally arise during the court hearings. So at any extension application or and so on, because the court will be looking at the general welfare issues for the child, not just extending the order. The court will be looking at access issues, placement issues, and parental engagement with social workers and any other services that they're being asked to engage with as well.
Okay. Um, and I think sometimes court is so overwhelming. It's very hard for parents to take everything in that space. So we would always recommend a follow up with the social worker to really figure out what it is in terms of parental participation they're being really asked to do, so that there's a clear understanding. So that's a great point. And just to kind of go a few steps backwards again, at the initial hearing, is if this is a parent's first time in court, they haven't had any other orders, be it supervision or emergency, and it's their first time in court, will the in-camera rule be explained to them in the courtroom or by their solicitor before they go in?
So in advance of the case, your solicitor will have the opportunity to explain it to you, or at least they should do. So they'll be able to hopefully quite clearly set out for you what an interim care order is, what its effects are, and what your options are as well. So they'll explain to you how the court case might run. So as you said, explain maybe the in-camera rule. So a parent needs to understand that the in-camera rule does apply, and they could find themselves in a spot of bother if they were to breach that to breach that rule. But the solicitor then would also have to explain to them what their options are as a respondent coming into the childcare courts. So that set out that your first option is to simply contest, which means to oppose or fight an order. And your solicitor then will explain that has consequences as to how the case will run. So the CFA will need to call their witnesses, they'll be cross-examined, and you present your witnesses, and then a judge makes a decision. So that's your first option, contesting the application. Your solicitor will explain then you also have the option to consent to an order, which means you're agreeing to an order being made. And a parent might do that for a number of reasons. So if they accept the order is necessary, or if they believe that the evidence is such that even if they oppose it, an order will be made. So it may be preferable to consider consenting so as to limit the amount of evidence that a judge actually hears. So that's your second option. You consent to the order. And then your solicitor will also hopefully explore with you any alternatives that might avoid the risk of the hearing going ahead. So you may consider engaging in safety planning that might satisfy and address any concerns, or you might consider agreeing to a lesser order, such as a supervision order, which is what we've discussed previously. And then lastly, an alternative to consider is a voluntary reception into care. So where the child is still technically placed in the care of the agency, but just not under a court order. So that has its own pluses and minuses as well. So your solicitor should hopefully talk you through all of this, and you'll have enough time to carefully consider your options, that you're not being kind of put on the spot to make any snap decisions, because it's a lot to take in.
Yeah. Yeah, that's a really interesting point around voluntary agreements, because that comes up a lot for parents. And I think there's obviously pros and cons to both. Uh, but just in your understanding, can voluntary agreements run in the long term, or are they a short term? Should they be used in the short term?
They can go on for as long as is necessary. Usually, if voluntary is going to be viable, you would hope that it is, just because it's going to be only a short-term arrangement, that the CFA are not looking to start this protracted, lengthy period of interim orders, that they would hope that just a short period is required for certain steps to be taken. Now, the Childcare Act, which is the legislation, the statute that covers these cases, so that actually expressly envisages voluntary care continuing right up until a child reaches 18. Okay. So it obliges the agency where a child is received into voluntary care to maintain that child in care as long as necessary, right up until they reach the age of 18. Now, the Child and Family Agency have certain policies in place, and their current policy around voluntary care is that it shouldn't go on for more than 12 months, or where they're not moving towards reunification. So their policies is slightly at odds with the law. So the answer is, how long is a piece of string, I suppose. Yeah.
And I suppose if parents in those situations, sometimes circumstances change and they may not be happy with the child's placement, for example, or may not be happy with some of the arrangements that are in place and feel it needs, they may feel it needs oversight of the court, or they might want to withdraw their voluntary consent. And I suppose what happens in those circumstances, if there's still thresholds met for the child being in care, or there's still concerns?
Sure. So a parent is entitled to revoke their agreement and consent to a voluntary care arrangement at any stage. And the Child and Family Agency then have to either return a child immediately to the parent, or bring an application to court to seek an appropriate order. So a parent is entitled to go up to the social worker at 10 to 5 on the Friday of a bank holiday weekend and say, I no longer agree to this. And TUSLA then either have to return the child immediately, or look for an emergency care order. Or if they're going to issue an interim care order application, try and see if the parent might agree to extend their voluntary until the matter comes into court. So that's one of the shortcomings from the perspective of the CFA around voluntary care, is that there is that kind of precarious nature where if an issue arises, a parent can quite suddenly end that consent, and the agency then have to take urgent steps or return the child.
Yeah. It's nothing is not complicated anyway, Stephen. It's very complex. There's a few questions coming through, and one is in relation to parental capacity assessment. So I suppose before I ask the question in the Q&A, is there an application for a parental capacity assessment to be, does that happen as a standard, or is it in unusual circumstances, or is certain criteria has to be met before there's an application for the parent to take part in a parenting capacity assessment?
So interim care orders are made and extended pending determination of the agency's application for a full care order. So it's during this period of interim care, the agency need to conduct their assessments about how and whether to return a child to their parents. As part of that assessment, they may form the view that they require the input of an expert, such as a consultant psychologist, for example, to conduct a parenting capacity assessment. So there's no application that's necessary to be brought to the court. It's very much a social work decision as to whether they believe it's necessary or not. And if they are proposing it, usually it's done by way of a joint letter of instruction. So it's not the Child and Family Agency directly engaging an expert. It's done jointly with the parents' lawyers. So there's full input and transparency into a letter of instruction, terms of reference. So everyone knows what's going to be asked of a parent, and that to make sure that it's done as openly and as fairly as possible.
Okay, and the question in the chat is just around, is there circumstances where a parent would be advised not to consent to a parenting capacity assessment?
Yeah, I think it can be somewhat of a double-edged sword. Yeah. Usually that circumstance or advice might be given where it is quite apparent that a parent has done well, has maybe taken significant steps, and feels that such an assessment might be unnecessary. It might be delaying matters unduly, in which case they may say, no, I'm not going to engage in that, but I will continue, to address the concerns. So that's a legitimate approach to take, but it does come with the risk of being seen as not engaging or being obstructive. So it's not, again, there's pros and cons, and it would very much depend on the individual circumstance of any case as to whether the advice would lean towards engaging or not engaging in an assessment.
But I think that first point you made there, Stephen, was really important as well, that it's not the terms and reference of a parenting capacity assessment are agreed between both parties as well. So it's there can be input by parents as well to what the purpose is and what it's looking at and how many sessions and all those type of things with a parenting capacity assessment as well. Just two other questions that are coming up is around, is there always a guardian ad litem part of the interim care order proceedings?
So this is a practice that differs from court area to court area. In the DMD, so in Dublin, it would be unusual for there to not be a guardian appointed in any childcare application. So there is a variance across the country, but there is new legislation that's been partly enacted that will kind of shift that. So there will be a presumption in favour of a guardian being appointed to a child in every case, unless there's specific grounds as to why there wouldn't be or why it's not necessary. So the long and short of it is, in Dublin, yes, there will almost always be a guardian, whereas in other areas, it depends on the individual practice of those courts.
Okay. And the guardian, I suppose, is there to represent the child's voice and the best interest of the child. Is the child themselves, if age appropriate and maturity and emotionally mature as well, are they ever invited in to speak to the judge or to give any of their opinions in person in interim care order hearings?
So one of the primary roles of the guardian ad litem is to give the subject child's views and wishes to the court. And obviously the level of their engagement and awareness will depend on their maturity and age and so on. So that's the primary mechanism which the child is involved in and heard in the court. So it's through their guardian ad litem, the child is heard. But there are other mechanisms. So in some circumstances, instead of a guardian, a child might actually be joined as a party to the proceedings and appointed as solicitor. So that would really only occur where the child is older and maybe has particular views that really wants to be advocated upon. So that's the other mechanism. And there is then separately a process where a child can come and just meet with the judge, but that's not for the purposes of giving evidence or anything like that. It's really just to kind of meet the decision maker in their case. So that's a good way of involving the child, but that also has to be carefully managed because certain issues might arise if a child says something to a judge or a judge says something that maybe shouldn't be said as well. So that has to be monitored carefully as well.
Very good. And just one of the question that comes up all the time for parents, particularly if this is their first experience of childcare proceedings and their first time in court, their children are still living at home. If the order is granted, will the children be removed that day, or is there room for arrangements to be made for the children to be removed over a period of time?
It is the usual practice that the children would be removed certainly that day. Ideally, that is done with the cooperation and support, I suppose, of the parent, who ideally will be able to support their child in what, of course, will be something extremely difficult for them. It may be that the CFA might delay the children coming out of the home, but usually where an order has been made and where a judge has made the finding that the child requires interim care, the agency are in a bit of a bind. They kind of have to act upon the order as well.
Yeah, definitely. And just double check, there's no more questions in the chat, but I think one of the final questions that some of our parents ask all the time is, especially when they're down in court and things, in what at interim care orders, is there normally a solicitor and a barrister, or just a solicitor, and what circumstances would a barrister get involved?
So the usual practice would be just for a solicitor to be assigned to a parent in the district court for childcare proceedings. The Legal Aid Board, in exceptional circumstances, can provide for a junior counsel, for a barrister to be instructed into the case as well. That's usually only done where there's a real particular complexity to the case, if there's maybe a novel issue of law arising, or primarily if there's a risk, if there's concurrent or similar and ongoing criminal proceedings, where there's a risk of prejudicing the defence of your criminal case by how you conduct the childcare case. That's a good reason to have counsel instructed in the childcare matters. So it's ordinarily just your solicitor, but occasionally there will be a barrister as well.
And can a parent appeal the judgment or the order?
Yeah, so any person can appeal any decision of the district court that they're not satisfied with. So if a judge makes an order, for example, the interim care order application, you are entitled to appeal that, and you have 14 days to bring your appeal and to file it in the court office. You can apply to the court for a stay on the order pending an appeal, but that will almost certainly be refused. So that would be where you ask a judge, okay, you've made the order today, I want to appeal it. Will you hold off actually letting that order come into effect until I have my appeal? So you can always ask first, but it's most unlikely to be accepted.
And is the appeal heard then in the district court, or do all appeals get a hearing? Or
so any appeal of a district court decision goes into the circuit court. So the circuit court will hear the appeal from the district court, and it's what's called a de novo appeal, which means it's entirely new. It's an entirely fresh application. So the Child and Family Agency, if it's first interim care order you're appealing, the Child and Family Agency will have to reprove their case in the circuit court, and you'll have an opportunity to challenge it in the circuit court then.
Does that happen a lot, Stephen?
Yeah, appeals do occur. I think sometimes maybe more orders should be appealed than are currently being appealed at the moment. So yeah, it'll depend on the circumstance whether there's any real merit in pursuing it. The advice may be that, okay, if the initial order is made, the best approach is actually to rather than challenge it in the circuit court, is to take steps to address what led to the making of the order in the first place.
We're just on 1:30 now, so that was a very quick half hour. So I thank Stephen for his time this lunchtime as well. And I think that was loads of information and really interesting. And I'm sure there's loads of further questions as well. We will be here next Thursday as well at lunchtime, where we're moving on, sticking with care orders, but moving on to a full care order. So I'd like to thank everybody for attending today as well. And the recordings will be available. And we're just going to share our feedback sheets now. So please do use it, and please keep sending in your questions or any questions. And if you have any further questions on voluntary or any of the orders we haven't covered, please send them in as well. And so I'm just going to let Sylvia share the screen now. And thank you very much for attending. Thank you, Stephen.
Thanks, Dave.
So you'll see on the screen as well that there's QR codes, which will bring you directly to our website, the Legal Aid Board website, our feedback form, and our previous webinar series as well. So are all in one place as well. So I'll just give a few minutes while people are hopefully giving some feedback. Thank you.